name's Tressler. I'm with Estelle and Kennedy. I'm going to go over the highlights of employment discrimination. This is a huge area of law. I'm going to kind of hit the highlights. If you have any questions afterwards, you can either come up or meet me out in the hall if we run out of time. So these are just the highlights, okay? First thing everybody needs to understand is that California is presumably an at-will state, meaning the majority of employees in California are at will. Your employment is presumed to be at will, means that an employer may discharge or take an adverse employment action against an employee for no reason, for a good reason, for a bad reason, for a mistaken reason, even if it's unwise or unfair. As long as it does not discriminatory, retaliatory, or harassing, they can make any employment action they see fit. Employer actually does not even need to give a reason for the termination or adverse employment action. A lot of employees feel like they are owed an explanation. Unfortunately, you're not necessarily owed one. Typical non-at-will employees, there are some of them. Government workers, such as teachers, county employees, law enforcement, firefighters, correctional officers, etc. Employees with contracts for a specific period of time are also not at will. An employer cannot discriminate, harass, retaliate against an employee who is a member of a protected class. It's a general overarching statement. There are many laws that state that, but that's a general maxim overarching all employment law. There are, like I said, many different laws that prohibit that conduct both federally and statewide. We're also going to focus on the ones that we're going to afford the most protection here in California. So the ones that are probably going to be most applicable to cases here in California. Generally, discrimination in employment refers to any situation where an employer treats an employee differently, harasses him, or retaliates against him because of sex, age, race, disability, or some other protected characteristic. In common vernacular, we use the terms discrimination, harassment, and retaliation interchangeably, but in California, the courts are going to make a very technical distinction between all those three terms. Those all have specific meanings in California, and different statutes are going to talk about those things differently. First of all, you have federal law and you have state law, just like in any area of law. So we're first going to talk about federal law. Federal law would apply to government employees, such as military, FBI, Amtrak, federal schools, Department of Transportation, Peace Corps, IRS, those types of, anybody that's a government employee, you're pretty much going to look first to federal law. You don't have to, but it is going to be your primary source. First pertinent statute for us is the Civil Rights Act of 1991, which makes it unlawful for any covered employer to refuse to hire, to discharge, or to otherwise discriminate against any person regarding compensation or terms and conditions of employment because of that person's race, color, religion, sex, or national origin. Now I'm going to go through a lot of those different types of classes. Some statutes protect for some certain classes and some don't, so it is kind of important because that's the kind of statute that you're going to make a case underneath. Does that make sense? The other statutes that you're going to look at under federal law that are going to probably be most pertinent here in California is the Age Discrimination and Employment Act of 1967. That prohibits discrimination based on age, and it's age over 40. Not a lot of people want to make a claim for discriminating against them because they're too young. There's no such thing. Usually, your age discrimination claims are going to limit it at 40 or up. The Rehabilitation Act of 1973 prohibits discrimination based on physical or mental disability. However, that statute is applicable only to federal contractors or recipients of federal funding. California law. The California Family Rights Act makes it unlawful for an employment practice, makes it an unlawful employment practice to discriminate against an employee who exercises his or her rights to take up to 12 work weeks leave to care for a child, parent, spouse, including pregnancy or maternity leave by either parent. Labor Code 132A also makes it unlawful for an employer to discriminate against injured workers who make or indicate their desire to make a workers' compensation claim. However, the overarching, most applicable law here in California is the Fair Employment and Housing Act. This is the one that's going to give you the most coverage. It actually gives you more coverage than most federal statutes, which makes it, Fair Employment and Housing Act, which I'll refer to as FEHA, it makes it illegal to refuse to hire or employ a person, refuse to select a person for a training program leading to employment, bar or discharge a person from employment or from a training program leading to employment, discriminate against the person in compensation or in terms, conditions, or privileges of employment based on a protected class. It can't just be they just do any one of those things. It has to be based on a protected class. Protected classes included in FEHA are the most extensive of any statute that's applicable to employees in California. That includes race, religious creed, color, national origin, ancestry, physical disability, mental disability, medical condition, marital status, genetic information, sex, gender, gender identity, gender expression, age, sexual orientation, and veteran status. Veteran status is new. That just was added about a year ago. FEHA is not applicable to uncompensated volunteers or employment within a federal enclave. I can get more into that, but if you think you might fall into a federal enclave, we can discuss that further. There is a distinction made in FEHA between discrimination and harassment as far as applicability of the statute. To sue under a discrimination claim, the employer must have 5 or more employees. To sue under a harassment claim, you basically just have to employ one person. So it's harassment parts of FEHA are going to apply to just about every business in California. Discrimination. The employee must prove the employer took an adverse employment action against the employee. The employee's membership in a protected class is a substantial motivating reason for the employer's decision. The employee was harmed, and that the employer's conduct was a substantial factor in causing the employee's harm. I get a lot of cases of people that call me. I field many phone calls a week. But it really comes down to, did they take an adverse employment action against you? Are the terms and conditions of your employment different in some way? And that reason for that change, that decision by the employer, was motivated by your membership of a protected class. Those are the key ingredients to a discrimination claim. All right, and an adverse employment action is defined as something that materially affects the terms, conditions, or privileges of employment to be actionable. The employee must prove that the adverse action resulted from the discriminatory motives rather than other causes, and that the discriminatory motive was at least a substantial motivating factor in the adverse employment decision. So if you want to think about it, it's kind of like that was the 51% of the reason why somebody made that decision. It could be other reasons, but if you can show that the majority of the reason or a substantial part of the reason was because of somebody's race, ethnicity, gender, sexual orientation, one of those protected classes, that's where you're going to potentially have a discrimination claim. So examples of an adverse employment action are obviously termination. That would be an extreme version of an adverse employment action. Demotion, and a demotion has to be evidenced by a change in salary or wage, depending on how you're paid. A less distinguished title, material loss of benefits, and significantly diminished material responsibilities. So you may, a new supervisor comes in and they don't like you because of your protected class, and they take away all your responsibilities, and now you're basically secretary, whereas before you were basically a manager. That would be an adverse employment action. So like I said, the distinction between harassment and discrimination under FEHA is very important to understand. FEHA discrimination provision addresses only explicit changes in the terms, conditions, or privileges of employment that changes some official action taken by the employer. In the case of an institutional or corporate employer, the institution or corporation itself must have taken some official action with respect to the employee, such as hiring, firing, failing to promote, adverse job assignment, etc. So it has to be an official action under FEHA to have discrimination.
A quick question. When it says significant change in compensation of benefits or
Correct.
less salary or pay, what if an employee does an excessive amount of overtime? Do they include that, and then all of a sudden, because of some
Yeah, if
actions?
they cut you off from overtime,
Pardon me?
if they cut you off from overtime, that would certainly be something, because that changes the terms of your employment. That determines how much you're making. The next thing we're going to talk about is the FEHA harassment. I got all that right? Yeah. That's what people commonly refer to as hostile work environment. That's not actually a thing. It is, but it's really under the statute, that's what harassment is, okay? So an employee, in order to prove harassment under FEHA, an employee must prove that employee was subjected to unwanted harassing conduct because of the employee's protected class, that the harassing conduct was severe or pervasive, that a reasonable person in the employee's circumstance would have considered the work environment to be hostile or abusive, the employee considered the work environment to be hostile or abusive, the employee was harmed, and that the conduct was a substantial factor in causing the employee's harm. Usually I see cases that aren't necessarily on point with these elements because the harassing conduct is not severe or pervasive. This is also a good time to mention that there is no law prohibiting coworkers or employers from being rude or jerks or just completely mean. There's no law against that. They can do that, unfortunately. However, they can't do that and be discriminatory. You can't treat one person that way and another people not that way.
Kind of a quick question. So then a coworker can say as many lies and stuff as they want about you?
That kind of toes the line into possible defamation. What we're talking about is, we're going to kind of get into some examples of what harassment is, so maybe I'll hold that off.
You can move on, yeah,
until a little bit later. So the things that we're seeing that make cases deficient in this area are the severe and pervasive area, and whether or not the average person would feel that it was harassing conduct, okay? It's difficult sometimes to separate yourself from maybe what another person may perceive that to be. But all these cases are determined by a jury of your peers. Are they going to think, when they're determining your case, whether or not you're overreacting or whether you're just being sensitive? Those are the types of things you have to think about. Can you remove yourself and say, would this make the average person be upset? Would this make the average person feel like they're existing in a hostile work environment? Okay? So those are the types of things to keep your eye out for. Okay? Harassment consists of conduct outside the scope of the necessary job performance conduct, presumably engaged in for personal gratification because of meanness or bigotry or for personal motives. Okay? So this is not something that's work-related. This is somebody's personal bias that is treating you differently in the workplace. Harassment is verbal, visual, or physical behavior that's so severe or pervasive that it creates a hostile work environment from the point of view of a reasonable person and the plaintiff. Okay, in harassment, unlike discrimination, no adverse employment action is required in order to prove a harassment case. Okay? What you have to show is that the environment is consistently hostile to you because of a protected class. You don't have to have an official action from the employer. You don't have to have an official action from a supervisor. It just has to be that severe and pervasive hostile work environment. That's how discrimination is different than harassment. Does that make sense? So there are many different forms of offensive behavior. I'm sure you guys have all heard many, many different stories of coworkers or even yourselves, unfortunately. There's verbal harassment, such as epithets, derogatory comments, or slurs. You have physical harassment, which is assault, impeding or blocking movements, such as standing in front of a doorway or standing in front of the entrance to your cubicle and not letting you leave. Physical interference with normal work or movement. Visual harassment, excuse me, such as derogatory posters, cartoons, drawings, clippings from magazines, things that are offensive in either somebody else's cubicle or in a common area. Or even, that can include emails that are mass emails sent out. Had that situation come up a couple times. Sexual harassment, we're going to get into that a little bit more in detail. But generally, it's unwanted sexual advances which condition an employment benefit on an exchange of sexual favors. That's called sexual harassment, quid pro quo. In a harassment by a supervisor, if the harassment is by a supervisor, the employer is strictly liable, meaning they're automatically liable. You can sue the employer and you can sue the supervisor. If the person that's harassing you is not a supervisor, the employer liability turns on a showing of negligence, meaning whether the employer should have known or did know about the harassment. This is why it's incredibly important to report harassment as soon as you see it. As soon as you see it, because if your employer doesn't know, how are they supposed to help you? And if the employer doesn't know, you're not going to be able to prove that they had any liability here, unfortunately.
So sorry, just a
Mhm.
question on that. So what if you do report it to a supervisor?
Yes.
And on the job site, and they just
I always
dismiss it?
always recommend that you report it to your supervisor. You also make a subsequent report to HR. Okay, saying, I reported to my supervisor on such and such date, such and such time, and in writing. Always make complaints in writing. You can make a verbal complaint, but also always follow it up with writing, whether that's an email, whether that's an official complaint form from your HR department. If you have a very small company, you may not have an HR department, but you need to make those complaints in writing. That's why it's so important to do that, so you can prove that you made a complaint and that you felt harassed and your employer did nothing. Okay, sexual harassment, which is any number of these things, okay? That's unwanted sexual advances, that's offering employment benefits in exchange for sexual favors, that's threatening reprisals or an adverse employment action after a negative response to sexual advances. So if you rebuff someone and then, they're targeting you. Visual conduct, leering, making sexual gestures, display suggestive objects or pictures, cartoons or posters, making or using derogatory comments, slurs and jokes, verbal sexual advances or propositions. We talked about that a little bit earlier. Verbal abuse of a sexual nature, graphic verbal commentaries about an individual's body. We see that a lot. A lot we see that. People say things flippantly and really are sexual harassment. That's one of the most common ones that I see. Sexually degrading words used to describe an individual, suggestive or obscene letters, notes, or invitations. And then there's obviously the physical conduct, which you hope you never see, but unfortunately still happens. Touching, assault, impeding, or blocking movements. So we talked about discrimination, we've talked about harassment. The third one under FEHA, which is most applicable to employees in California usually, is retaliation. This is all applicable in federal law as well, but again, I'm applying the FEHA standards because those are going to offer the most protection. Okay. Retaliation generally takes place whenever an employee is subjected to some type of job detriment or serious emotional distress for opposing, complaining about, or participating in the investigation or prosecution of unlawful discrimination or harassment. Okay, FEHA makes it unlawful for an employer to discharge, expel, or otherwise discriminate against any person because the person has opposed any practices forbidden under FEHA, filed a complaint, testified, or assisted in any proceeding under FEHA. It may also occur when an employer takes an adverse employment action against an employee who refuses to violate the rights of others. So like discrimination, an adverse employment action is required, okay? Not like harassment. Harassment is showing that the hostile work environment. So there are distinctions made here. Retaliation is not that it's based on a protected class, but because somebody is targeting you for making a complaint or standing up for something that you believe is illegal. Okay? Employee's conduct may constitute protected activity not only when the employee opposes unlawful conduct, but also when the employee opposes conduct that he or she reasonably and good faith believes to be discriminatory, regardless of whether the conduct complained of is ultimately found to be in violation of FEHA. This is to protect you as the employee. Are you an attorney? No. I mean, are you in that split decision thinking, I wonder if that's illegal? If you reasonably believe it's illegal and you make a complaint about it, and then you get some sort of adverse action against you, that's retaliation. It doesn't necessarily, if you reasonably believe it, and don't just fake it. You can't just say, oh, I really thought that was illegal. If you can make a reasonable argument that you thought that was something that was illegal, and that's why you complained about it, or you stood up for somebody else who you thought was getting exposed to illegal conduct, then that's retaliation. You don't have to be right in your determination, you just have to be pretty sure at the time that you did it, that you made the complaint that it was illegal. Okay, so for retaliation claims, you have to prove that the employee was engaged in a protected activity, meaning a complaint of some sort. The employer subjected the employee to an adverse employment action. The employee's participation in the protected activity was a substantial motivating reason for the employer's decision. The employee was harmed, and the employer's conduct was a substantial factor in causing the employee's harm. So they're very similar to the elements of discrimination, but the motivation is retaliation instead of the protected class. Labor Code 1102.5 is incredibly important. This mandates that an employer may not retaliate against an employee for disclosing a violation of a state or federal regulation to a governmental or law enforcement agency. That's very similar to FEHA. However, under this labor code, it also protects employees who report suspected illegal activity to a person with authority over the employee or to another employee who has the authority to investigate, discover, or correct the violation or noncompliance. See how that, you don't have to report it to an outside agency. You just have to report it to a supervisor or to a manager, somebody that's higher up than you that has control over your employment. And that's just a recent development out of this labor code, which allows for many more retaliation complaints, because a lot of people will internally complain to maybe their boss, their supervisor, their manager, however your company is structured, but don't ever report it to an outside agency. So I don't want to do that. That seems like a pretty extreme way of addressing the situation. And so a lot of people don't do that outside agency. That's what we recommend, okay? If you feel like something illegal is happening, we recommend that you report it to an outside agency. And then if you're retaliated against because of that, then you can say this, I made this complaint on this day. However, this statute now allows you to make that complaint to a supervisor. That results in retaliation, violation of this labor code. So common defenses to retaliation claims that you need to keep an eye out for. That there is a legitimate non-retaliatory reason for the adverse employment action. You say, oh, I made a complaint on this day, a month later I got terminated or I got suspended or something, and it seems like it's motivated by the complaint that I made. Well, could it also have been motivated by the fact that you are no call, no show for like 4 days in a row? That's the type of defense that you want to keep yourself out of, okay? So if you make a complaint, you better be on the up and up regarding your employment. You better not do anything else wrong, or they're just going to say, oh, that was the reason why. You were late. You were not following employer rules or whatever. They're going to issue some more scrutiny to you, so you better be able to stand up underneath. They find out about, a lot of the times this comes up with a resume or a job application. They find out that you lied on that. And they say, oh, we would have never hired in the first place. Or we would have terminated him a long time ago if we knew about that. Or on-the-job misconduct that they find out about after they've already done their adverse employment action. They would be justified. That would be a defense to their actions if they now determine some reason why they could have terminated you any time before that. So, general advice, follow all the rules. Always follow all the rules, okay? Because there's going to be even more scrutiny on you if you feel like you're in a situation where you're facing discrimination, retaliation, or harassment. There's going to be so much more scrutiny on your employment that you need to make sure that you follow everything to the T. Everything. Meaning, be very familiar with your employee handbook if you have one. Know all your rules and regulations. Should it be that way? No, but it is that way. This is also a separate cause of action, failure to prevent discrimination or harassment. Under FEHA, it's unlawful for an employer, labor organization, employment agency. So there's a lot of people that are employed through an employment agency. They're also subject to FEHA. An apprenticeship training program or any training program leading to employment to fail to take all reasonable steps necessary to prevent discrimination and harassment from occurring. This cause of action can also arise in the event that you've made the complaints and they haven't remedied you in any certain way. This person's harassing you. They didn't move them. They're right next to you. They're in the cubicle next to you. They didn't do anything about it. They just let them stay there. Or they continue to send you out in the field together to do whatever work you are doing. It can, there's lots of different actions an employer can take in order to relieve them of liability by making some sort of reasonable action. Okay, so disability discrimination. We have federally the Rehabilitation Act of 1973. Federally, we have the Americans with Disabilities Act, Amendments Act of 2008, and again, FEHA. The Federal Rehabilitation Act applies to all federal agencies, federal contractors and subcontractors working on federal projects, and private employers receiving federal financial assistance. You have the American with Disabilities Amendments Act, applies to all private employers with 15 or more full-time employees, regardless of whether the employer has federal contracts for receiving federal funds. The ADAA defines disability as a physical or mental impairment that substantially limits one or more of the major life activities of an individual, a record of such impairment, or being regarded as having such impairment. Okay, so each of these statutes is going to define disability differently. Major life activities that they're talking about: caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, just about everything. Anything that interferes with the bodily function, immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory. I think everybody's probably got one of these, honestly. But it has to be diagnosed, okay? It has to be diagnosed. An impairment that is episodic or in remission constitutes a disability if it would substantially limit a major life activity when active. So we're talking about things like, especially autoimmune disease, you see this a lot. Cancer, all those things that, aren't necessarily bothering you on a daily basis, but if they were active, they would limit a major life activity. It prohibits consideration of ameliorative effects of mitigating measures, meaning that they can't take into consideration that you do things to counteract the symptoms that you feel, such as medication, medical supplies, equipment or appliances, low vision devices, that's not including glasses or contact lenses, prosthetics, hearing aids, cochlear implants, mobility devices, etc. They can't take into account that you use those things, and so you shouldn't be counted as having a disability, okay?
Can you repeat that again?
They can't take that into account. You either have a disability or you do not. It doesn't negate the disability by having to use a prosthetic, or you have a disability regardless of whatever you do to counteract the effects. Does that make sense? So you are deaf in one ear, but you have a cochlear implant, or you use a hearing aid that gets you back up to almost normal hearing. You still have the disability. Does that make sense? So it's still there even if you're doing things to make up the difference between how it affects your daily life.
Like if you're doing things to manage it.
Correct. Medication, right? Okay, so you have depression or anxiety, and you take medication for it. When you're on medication, you're fine, but you still have the disability. Does that make sense? All right, so under FEHA, it provides protections independent from and broader than those in the ADA. Okay, FEHA, again, is going to provide you the most protection. However, it does not include sexual behavior disorders, compulsive gambling, kleptomania, pyromania, or psychoactive substance use disorders resulting from current unlawful use of controlled substances or other drugs. There's a reason why they have to place that. There's a reason that that's all defined, because people do try to sue for those things.
Does this include alcoholism?
Alcoholism can go both ways. Definitely can. There are cases that have been successful in alcoholism, but requires a significant amount of proof. Unlike ADA, FEHA does not have any statutory caps or compensatory damages or punitive damages. So financially, it's better for you to bring a complaint under FEHA than it is under any other statute for disability. The employee must prove that the employee is a person with a disability or medical condition. The employer made an adverse employment decision, and it was because of the disability. Okay, again, you have to link the motive with the adverse employment action. Okay. Disability discrimination has the same elements as regular discrimination, but it's more specific, just specific to disability. Okay. FEHA specifically defines disability as a restricted capability to perform particular activities, an inability to perform some of all tasks of daily life, a medical condition diagnosed medically by a doctor restricting activities, and the common activities referred to in FEHA are eating, sleeping, walking, standing, lifting, bending, reading, concentrating, and thinking. And I don't have a slide on this, but it is important to mention, as you discussed earlier, that your employer is required to make reasonable accommodations for a disability. The word reasonable is a nice big legal word that we use all the time, and it really is dependent on what cases have decided before. Okay, so it's reasonable that perhaps if you have back problems, to get you a chair that is good for you, okay? Or to get you wrist, the keyboard things for your wrist, or, you know, whatever it is that you have, if it's reasonable, if it's not costly, if it doesn't impair their business in some significant way, they have to make that accommodation for you, okay? And the policy behind that is that people don't want, well, the state of California does not want employers just kicking people out because they have small limits on their inability to work, okay? That's why your employer is required to make reasonable accommodations for those things. How to file a complaint. Okay, at both the federal and state level, the employee must file an administrative claim via appropriate government agency before he or she can properly file a lawsuit based on a statutory claim for discrimination, harassment, and/or retaliation. In California, you file that complaint with the Department of Fair Employment and Housing, and federally, you file that with the Equal Employment Opportunity Commission, that's the EOC. For a FEHA complaint, file it with DFEH, that's dfeh.ca.gov. It must be filed within 1 year of the unlawful act, okay? 1 year is not a long time at all. So if this is something that you feel like is happening in your employment, you need to act quickly. You can allow DFEH to investigate and issue findings, or you can simply just file a complaint or request a right to sue and file a litigation. Similarly, you're going to file a complaint federally with the EEOC, that's eeoc.gov. That must be filed within 180 days of the unlawful act, which is about 6 months. So the timeline on that is even shorter, okay? Again, like FEHA, you can allow EEOC to investigate and issue findings, or you can just request an immediate right to sue. Yes, ma'am?
What if it's a continued, ongoing situation?
There are situations that provide for the continuing violations, okay? That is something that you would need absolutely to speak to an attorney about, because there's specific criteria that you would have to prove for a continuing violation. They have to be similar, they have to be continuous, they have to be, I don't want to get too much into that now, but if you certainly need to be cognizant of your statutes of limitation on here when you need to make your complaints. If you think that you're even remotely close to this, you need to talk to an attorney. Okay, even if it's a consultation and not retaining an attorney, you need to talk to somebody to get some legal advice as to when you think your statute of limitations is up. So at least you know what time frame you're looking at. Advice for filing complaints. Please consult an attorney before filing a complaint with either agency. And do so well in advance of when you think that period is expiring, okay? To allow your attorney enough time to determine what causes you are going to put in your complaint. Once you file your complaint with the agency, that determines what you can later sue on, okay? So if you don't put enough stuff or you don't put the right stuff in your original complaint, you're going to then be prohibited from doing that in litigation, okay? So complaints are more complicated than they appear. They're very simple, but the information that must be included in those things must be correct, okay? They're easy to fill out, yes, and they look approachable, and they are for that purpose, because they want to make it easy for someone to file a complaint. However, the gravity of that complaint is very high, okay? Because you're stuck with that complaint once you make it. Like I said, the complaint you file determines what type of cause of action you may litigate once you sue in civil court. And it's very, very difficult to revise or amend a complaint, so it's important to complete it correctly the first time. I think under EEOC now you can't make modifications yourself. You have to actually call an agent and have them modify the report for you, which is, when you contact the government to do anything, you know that's not going to happen quickly, okay? So you certainly want to make that complaint right the very first time, which is why you should get some legal advice, at least to fill out the complaint. If you believe that you face discrimination, harassment, or retaliation, contact an attorney as soon as possible, because we have already talked about that short statute of limitations. If you're an employer and you want to protect your company from these types of claims, there are proactive steps to take. Contact an attorney to determine what's right for your business. So you can give our office a call. We have free 15-minute telephonic consultations. Unfortunately, I think I forgot my cards. No, I just have my purse. But you can have a detailed consultation. Usually these cases, we can give you an idea over the phone whether we think you possibly have a claim, But all these cases are going to be very document driven too, so we want to see your complaints, we're going to want to see your employee handbooks, we're going to want to see a lot of the documents from your personnel file. Those are the types of things that are going to show us what's been going on in your employment, whether there's any external evidence that's going to support your claims, because that's what's going to make the difference between a strong and a weak claim. Okay? We have several offices that you can have consultations at our LA, our Upland, or Mission Viejo office. You can give us a call and we can do that free 15-minute over the phone. But otherwise, we really highly recommend, we offer consultations in our office for an hour. It's $300. $300 is far more effective at completing your analysis. It sounds like a lot of money, but if you're foregoing a case or if you're missing causes of action, you can't get those back. So we highly recommend that if you think that you have any one of these claims, that you pursue it via a full consultation. But we will certainly do the 15 minutes with you on the phone for free.